Welcome to Employment Law This Week. I'm George Whipple. As return to work continues, some employees have new caregiver responsibilities due to the pandemic. The EEOC has released guidance to help employers support those employees while avoiding caregiver discrimination. Epstein, Becker Green's Ann Knuckles Mahoney tells us more.
The EEOC recently released a technical assistance document on the COVID-19 pandemic and caregiver discrimination under the federal employment discrimination laws. It also updated its What You Should Know COVID-19 question and answers document to include additional questions on this topic. And these documents provide guidance to employers on how caregiver discrimination can arise in the workplace as it relates to COVID-19 and the employees' and applicants' caregiving responsibilities. Federal discrimination laws do not include caregiver status as its own protected characteristic. Instead, the guidance explains how caregiver discrimination can violate federal anti-discrimination laws such as Title VII or the ADA, when it is based on an employee's protected characteristics such as sex, which would include pregnancy, sexual orientation and gender identity, or race, color, age, or the other protected characteristics under these laws. Unlawful discrimination can also arise when it is based on a person's association with an individual who has a disability as defined under the ADA, or when that discrimination is based on the race, ethnicity, or other protected characteristic of the person for whom the employee or applicant provides care. The EEOC advises employers that they are not required to excuse poor performance that arises due to caregiving responsibilities. For example, if the employer has a policy where they give written performance warnings to employees after being repeatedly late to work, the employer is allowed to give such warnings in similar circumstances, even if the employee is late because of their caregiving responsibilities, without running afoul of violating the discrimination laws. The EEOC, however, as an alternative, suggests that employers analyze their workplace and determine the circumstances under which adjustments can be made for all employees. And when applying or permitting such adjustments or flexibilities, the employer act in an impartial, non-discriminatory manner.
Thanks, Ann, and thank you for watching. We'll see you next time.